Young Thug's lawyers Brian Steele and Keith Adams have filed a supplement to motion to recuse Judge Glanville. It says Judge Rachel KRAUSE must be recused because Glanville donated $2,000 to her campaign back in April. What do you know? KRAUSE and Glanville are homies, and they're donating to each other's campaigns pretty much. And now she has to recuse him. Judge KRAUSE responds to these motions later in this video, so stick around, hit subscribe, join the channel membership. It's only 10 cents per day. Here we go. All right, so here's Brian Steele and Keith Adams' document right here. Supplement to motion to recuse Judge Glanville. The supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for the following motion to recuse shall not be later than 5 days after that affiant first learned of the grounds. This motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all three are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. And then they cite a case for Reed vs. State. But Brian Steele still plans to call them as witnesses. This motion also timely moves to recuse the Honorable Judge KRAUSE based upon the fact that she sits on the Fulton County Superior Court bench with Glanville, and that in April, Glanville contributed $2,000 to Honorable Judge KRAUSE's re-election campaign. The judge has to decide whether or not to kick Glanville off the case has been given donations by Glanville. Absolutely insane. Now it also says KRAUSE donated $500 to Glanville's re-election, but apparently that was redacted now and that's not in the official document anymore. Like, I guess Brian still got that wrong. Undersigned counsel derives no happiness when filing the supplemental motion. However, let justice be done thou the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. Oh boy. Steele is not playing games. Alright guys, this video is sponsored by BetterHelp. You know, we all need someone to talk to from time to time. It's completely natural. Therapy can help you with better coping skills, stronger relationships, and a better sense of who you are as a person. I know a lot of you have gone through something traumatic, and it's really good to get all of that out and not hold it in and harbor it. For someone like me, BetterHelp is amazing because it's all online. You don't have to do it in person. It's extremely convenient and flexible, and you can fit it in your schedule and you get to talk to someone. Life is all about having fun and having a clear mindset. Mental health is very important, and BetterHelp can be something that you use to be a better person in your work life and obviously your personal life as well. I've personally witnessed people around me that go to therapy and they're in a dark spot, and months later they come out a different person. They're more energetic and they're happier in general. So all you have to do is click the link down below or go to betterhelp.com/cuff and get 10% off your first month, and you fill out this questionnaire and you'll get matched with a licensed therapist, and you can change this therapist at any time if you feel you need to. Stop holding everything in and go talk to someone. Go to betterhelp.com/cuff. That's betterhelp.com/cuff, and you'll get 10% off your first month. This is a hell of a deal. Start focusing on yourself. You deserve it with BetterHelp. Trust me, guys. Here's the rest of the video. Additional reasons for this recusal were first learned on Monday, July 1st, 2024, when Glanville permitted the court reporter to release the undersigned counsel the transcript from Monday, June 10th, ex parte meeting between Glanville, Hilton, Love, Bumpus, and her client, sworn witness Copeland. In the case of bar, Glanville's ex parte communications with the sworn witness, lawyers Love and Hilton, are seemingly only partially captured by the court reporter. So that's what Weinstein was saying. He believes his affidavit was 100% accurate, but the court reporter, Miss Weaver, wasn't in the room to, type it out or whatever. Judge Glanville, lawyer Love, and Hilton have prejudiced and tainted Mr. Williams' trial so deeply, as Judge Glanville has not acted as the judge, but morphed into an essential part of the prosecution team. Oh man, oh man, oh man. Communication with the prosecutor during trial resulted in the appearance of bias, requiring reversal of the convictions and sentences. So he cites a case Johnson vs. State where that happened. USCR 4.1 mandates the judge shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impending proceeding. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to these meetings as privilege and describing the improper secrecy as sacrosanct. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Bro, Brian Steele is so good. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Cites Pendergrass vs. Skeleton again. Rule 2.9 of the Georgia Code of Judicial Conduct forbids judge from considering ex parte communications as judges shall accord to every person who has a legal interest in the proceeding, or that a person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were privileged. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or their lawyers concerning pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts or court personnel. And so remember, the judge was saying this was an emergency to explain to Woody his immunity deal and all that bullshit. It is also clear that the ex parte communications are presumed to have been in error, and once a party is shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. See Hargis vs. State. In the case of Barr, there's not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications as captured and attached Exhibit B resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. Brian Steele's basically saying if we go to if we start the trial back up and Mr. Williams is convicted months from now or whatever, either way, I'm going to appeal this shit and it's going to get reversed. So this is all going to be a big waste of time, even if the trial goes on and no one gets recused. As shown in the joint affidavit attached, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District Attorney's Office as he dispensed legal advice and supported lawyers HYLTON and Love's goal to have Mr. Copeland testify against Mr. Williams and other co-indictees. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. That's what I was saying, man. Like, the judge was, you know, explaining a little bit too much to Woody to get him to go up on the stand. Woody was acting dumb and didn't know the difference between purging his contempt and perjury, like witness lying on the stand or whatever. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases which the judge has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of disputed evidentiary fact concerning the proceedings of Code of Judicial Conduct Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel this afternoon, June 10th, Lawyers HYLTON and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's lawyers Love and lawyers HYLTON's improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams. I wonder what Miss Love and Miss HYLTON are thinking here, dude. Do they actually think that there's nothing wrong here? Like, does Judge Glanville actually think all this was proper? I don't understand how they could possibly think that. In the state of hand, the state cannot show that Judge Glanville, lawyers Love or HYLTON, intentionally or willfully, complicitly, in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Glanville and his two cohorts from the Fulton County District Attorney's Office, while Mr. Copeland changed Mr. Copeland's stance not to testify against Williams. Copeland refused to testify. All of his prior false, inculpatory statements as to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation. Intimidation tactics thrust upon Mr. Copeland by the combined work of Glanville, Love, and HYLTON. I kept saying that when I read the full transcript of my video. This shit was pretty much witness intimidation. Like, you can purge right now and get out of jail, or else you're going to be in jail for years on end if you don't testify. Resulting in Mr. Copeland's decision to testify, and thus Mr. Williams is another witness to challenge at trial, citing more cases. Ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because ex parte communications are presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Glanville's lawyer Love and HYLTON's improper ex parte communication with witness Copeland. The cover-up, the secrecy, and silence of these three team members is unforgivable. After the Star Chamber meeting, the three public officials simply strolled in the courtroom and faced the cameras, called for the jury, and feigned to continue his trial as if nothing out of the ordinary occurred just hours, minutes before. Links the YouTube stream, bro. Bride Seal's a legend. They strolled to the courtroom, acting like they didn't just fucking intimidate a witness to get on the stand. Mr. Williams needs to examine Glanville, HYLTON, Love, and all other members of the prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Glanville, Love, and HYLTON, all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County and the state of Georgia and America has been attacked by the conduct of these three actors. This injustice must end, beginning with Judge Glanville removed and disqualified Mr. Williams' case. Therefore, this motion is also made timely for Love and HYLTON to be removed and disqualified. Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of the lawyer Love and HYLTON. Jesus. Fucking Brian Steele's coming for everyone, baby. Judge Glanville did the opposite of recusing himself, even though he is keenly aware that helping lawyer and Love HYLTON influence Mr. Copeland to change his mind and to testify against Williams is not permitted by any judge in any court. Instead, Glanville, the chief judge in the Superior Court of Fulton County, has taken upon himself, at the behest and encouragement of lawyers Love and HYLTON, to ally himself with the prosecution in this case. Judge Glanville's misconduct shall not stand. The law must be followed. Glanville must be recused and disqualify Mr. Williams' case. No hearing is needed. This basically just says no hearing is needed. It's fucking case closed. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and stains courts throughout the state of Georgia and our country. What occurred in the Star Chamber, outside the view of the cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public, is unpardonable. Judge Glanville, lawyer Love, and HYLTON have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and the outside of the lens of the camera. These public officials shall never be trusted by Mr. Williams and undersigned counsel. There are serious consequences for these intentional and unjustified misdeeds that have not been dispensed. The clear evidence is that Glanville is not impartial, or there is at least the appearance that Glanville is not impartial. Judge Glanville must be removed. Star Chamber cannot prohibit Brady evidence from coming forward. That is exactly what Glanville did. In the transcript, Woody never said, "I killed Donovan Thomas," but apparently Mr. Weinstein is very confident that happened in there. Like, apparently Woody said that. It's not in the transcript. He just said, "I did these crimes," and it was very vague. Mr. Williams' constitutional right to due process, a fair tribunal and fair trial, effective assistance of the counsel, right to cross-examine, right to see, hear, and be present for the statements of a sworn witness that have been obliterated by Glanville and his cohorts. Star Chamber meeting between Judge Glanville and Love and Hilton undermined the public's faith in the integrity of the justice system as it conceals from the public, Mr. Williams, his lawyers, and others facing the removal of their liberty-critical information about the lawfulness and reality of how they are being prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Glanville, lawyer Love, and Hilton. Glanville in the ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under the Code of Judicial Conduct and constitutional violation of due process. They cite Dukes v. State. Williams' constitutional rights to due process has been violated because not only is there an appearance of partiality, but there is actual bias as Judge Glanville has been embroiled in this trial and is assisting the prosecution team to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. However, neither Judge Glanville, lawyer Love, or Hilton uttered a word that they spent the morning of June 10th leaning on Mr. Copeland to testify for the prosecution against Mr. Williams. Coaching Attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify at trial. Coaching Mr. Copeland how to deliver his testimony. Promising Mr. Copeland that he would not be prosecuted for perjury unless he told a bold-faced whopper. These public officials heard and failed to reveal that Mr. Copeland confessed to committing every indicted offense in this case. Wait, what? Okay. See, that's a little bit of a reach by the defense right there. He said, I did these crimes, but let's be honest, he didn't do every single crime in the whole RICO trial, bro. Even non-lawyers can see that Glanville, lawyer Love, and Hilton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded for the opportunity to continue. I love how Steele just keeps pointing out, like, Glanville's part of the prosecutor team now. Glanville originally denied Mr. Williams' request for access to the June 10th ex parte hearing transcript, keep contents of the record totally hidden by lawyers. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct worked to effect change. They released the transcript. Glanville, lawyer Love, and Hilton were duty-bound to immediately announce to Mr. Williams, his counsel, and all accused, and their counsel this ex parte meeting occurred. Brady evidence was obtained, and the transcript was made and allowed argument to flow. Instead, their cover-up equals their misdeeds. They hid Brady evidence, attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus on how Brian Steele learned of the proceeding. I forgot that Brian Steele was held in contempt over this bullshit. Oh my god, what a disaster. There's no daylight between Glanville and lawyers Hilton's improper and unethical conduct. All must be removed from Mr. Williams' case. Cite Roberts v. State. Mr. Williams intends to call Judge Glanville as a witness to trial, as well as this recusal motion evidentiary hearing based upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional right. There appear to be communications not captured in the transcript of June 10th ex parte meeting. Lawyers Love and Hilton and Glanville examinations are needed to complete this record. Oh boy. Judge Glanville is a necessary witness to Mr. Williams' trial, and his name will be used when undersigned counsel cross-examine Mr. Copeland. Oh shit. Whether Judge Glanville pressured Mr. Copeland to testify and whether Copeland realized that Glanville was allowing wrong propositions of law to be explained to him. The fact that Glanville condoned Mr. Copeland lying under oath unless it was a bold-faced whopper. This mandates the Judge Glanville cannot be in the courtroom in front of Mr. Williams' jury ever again as judge. Judges must be disqualified in proceedings which their impartiality may be reasonably questioned. The bias of Judge Glanville is of such nature and intensity to prevent Mr. Williams from obtaining a trial free from Judge Glanville's bias and prejudice, bias, or prejudgment, or even exist. Facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutors, Love and Hilton, from the truth of their misconduct, denied Mr. Williams' motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse, dated June 17th. This demonstrates that Judge Glanville is involved in the controversy and cannot be deemed fair and impartial. Sentencing Brian Steele to the maximum number of days to serve in custody for nothing but zealously and ethically upholding his professional responsibilities. Mr. Williams must be granted a reasonable bond. Mr. Williams' statutory right to speedy trial has been totally upended by lawyer Love, Hilton, and Glanville, and Mr. Williams must be cleared of all baseless charges. Judge Glanville will be called as a witness by Mr. Williams. The law mandates that Judge Glanville will be removed from presiding over Mr. Williams' case because he cannot be both a witness and a judge in our lawful criminal justice system. Judge Glanville is giving lawyer Love, Hilton, and the Honorable Attorney Bumpus and witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Bro called it the kangaroo court. These distinctions between the roles have been washed away in Mr. Williams' case. Judge Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial towards the lawyer Love and Hilton in Fulton County District Attorney's Office. Glanville's impartiality is more than questionable and is an error to permit him to continue on Mr. Williams' trial. Glanville, Hilton, and Love have stolen forever Mr. Williams' opportunity to have this trial heard by by a jury in a constitutional and statutory firm manner. All of the conduct in all proceedings after the Honorable Douglas Weinstein, as well as undersigned counsel, filed their motion to recuse. Affidavits are deemed invalid and have no effect. Mr. Williams' constitutional statutory right to a speedy trial has been stomped on, as well as Mr. Williams' right to due process in fair tribunal. The Honorable Court of Appeals of Georgia has explained, as cited above, the Commission concludes that it would be inappropriate for this Honorable Court to preside in this action where Glanville holds a judicial office in the Honorable Court's same circuit. Therefore, under law, this Honorable Court must recuse from this case. Furthermore, this Honorable Court has received a $2,000 donation to its re-election campaign from Glanville in April 2024 during their pendency of Mr. Williams' trial. Glanville giving this contribution for re-election could be deemed as exceptionally large campaign contribution, and thus another reason this Honorable Court must recuse presiding of this case. So he's talking about, obviously, Rachel. So here's the affidavit that they kept talking about. Purpose of the ex parte meeting between lawyer and Love, HYLTON, and judge was act in unison in order to influence sworn witness Copeland to testify. No lawful purpose for this ex parte hearing to occur. There's no allegation by Mr. Copeland that he was somehow threatened. There's no allegation by Mr. Copeland that he was not satisfied with his counsel. There's no allegation by Mr. Copeland that he was needed to meet with the judge. Meet with sworn witness Copeland to impress upon Mr. Copeland that he needs to testify for the same reasons lawyer Love announced in the open court on Friday. Lawyer Love made untruthful statements about email correspondence with the Honorable Jonathan Manick. Remember, Woody's lawyer said, if that's what you think, fuck yourself or whatever, to Miss Love in an email because she accused him of, being in the best interest of the defense. Lawyer Love continues to make false representations, and Glanville knows if he has paid attention all during the proceedings, lawyer Love makes intentional misstatements of fact routinely. Yet lawyer Love defects from misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Glanville has thrown away all appearance of propriety by permitting this ex parte meeting to occur at the behest of lawyer Love and lawyer HYLTON. Glanville is not independent, as being led by the nose by members of the Fulton County District Attorney's Office. This is because Glanville is a member of the prosecution team. The fact that Glanville is dispensing legal advice and strategies to attorney Bumpus, guiding her on how to speak with Copeland in order to have her client testify against Mr. Williams is clear. Direct fact that Glanville has forfeited his judicial role. Lawyer Love then inaccurately bashes attorney Melnick by saying there's an assertion that people are representing Mr. Copeland's interests. The biggest concern is Mr. Copeland's best interest, and they are just not here. The motherfucker had non-refundable tickets. There is absolutely no reason that Judge Glanville and Lawyer Love are discussing what attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Lawyer Love to ridicule attorney Melnick. Glanville and Lawyer Love jointly explained to attorney Bumpus that attorney Melnick injected himself into these proceedings. The fact that Glanville is having these conversations in the first place, then agreeing with and championing the prosecution's calls and mandates, even to a casual observer, that Glanville's bias against Mr. Williams and favors the prosecution. The great bias cannot be more clear when Glanville explains to attorney Bumpus that she needs to give sworn witness Copeland the questions that the state is going to ask him when he testifies, and to ask Mr. Copeland to tell attorney Bumpus they, meaning Mr. Williams and his co-indictees, might ask about. Further, as long as attorney Bumpus has acknowledged of all of the crimes sworn witness Copeland has committed, it is ridiculous to claim that Glanville is not biased and is impartial. Glanville continues to explain to attorney Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is the defense know more about Kenneth Copeland than anyone else, so they are probably going to kind of... What gives Judge Glanville the right to state that Mr. Williams knows more about Mr. Copeland's supposed bad conduct than anyone else? In reality, Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt onto Mr. Williams. Damn, that's actually a really good point. Glanville is kind of putting guilt onto Mr. Williams knowing more. Glanville has the audacity to bring sworn witness Copeland to his chambers without the request of Bumpus and at the request of Love. From 9:34 to 10:03, nothing was recorded by the court reporter. A client will call lawyer Love, HYLTON, and Glanville to probe what occurred during this period. So that's the period where they say the court reporter didn't put anything down, I guess. It is hard to articulate how wrong this ex parte summit is and how obvious it is that Judge Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Glanville's bias in this case is constitutionally broken because of the conduct of lawyer Love and HYLTON. Why is Judge Glanville inviting Mr. Copeland, a represented party, to ask questions of lawyer HYLTON and other members of the district attorney's office of Fulton County or the court? This is beyond comprehension for an impartial seasoned jurist to act. This is because Glanville is not acting as an impartial seasoned jurist, but as part of the prosecution team and must be recused. Dude, this is so much. They just keep citing so many points. Mr. Copeland states, I've never been truthful a day in my life until I just made this statement right now. This is quintessential Brady evidence. Judge Glanville never uttered a word, nor did lawyer HYLTON. They did not provide the defense this Brady evidence. Same as unconscionable. A client intends to call Glanville as a witness at trial, as well as lawyer HYLTON discussed the failure to reveal this information. Lawyer HYLTON gives inaccurate legal information on whether Copeland can be prosecuted at all, and gives some far-fetched ideas about the federal statute of limitations and the state of Georgia statute of limitations. Glanville sits idly by and allows lawyer HYLTON to misinterpret sworn witness Copeland that he cannot be prosecuted for crime. Anyone with a modest interest in this case would know that the prosecution has called Mr. Copeland an unindicted co-conspirator, and that the supposed RICO conspiracy statute of limitations continues today. Thus, Mr. Copeland could be prosecuted both in federal court and in the state of Georgia for crimes. This is wholly contrary to what lawyer HYLTON and Glanville allow Mr. Copeland to believe. See, that's not good. That's like misleading a witness, like straight up kind of. Mr. Steele saying they're lying to get they know that was wrong. Glanville reinforces lawyer HYLTON's wrong information because Glanville is part of the prosecution team. team. Glanville tells Copeland that he will not be prosecuted for any crime. Glanville and lawyer Hilton are acting as one, not separate, as required by law. Importantly, Glanville again asserts that Mr. Williams and the other co-indictees may know your business, but if they ask you about things that you might have some liability with, you can't be prosecuted for any of those. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors because Mr. Williams is a co-conspirator with Mr. Copeland. Glanville is far from acting as an impartial judge. Copeland puts an end to this, says he doesn't want to testify because he will be a bad example for his family. One must ask, why is this ex parte conference occurring and why does it continue? The only logical answer is that the judge, Glanville, lawyer Love, and Hilton, acting in concert, had an agenda to ensure that Copeland testifies against Mr. Williams in order to convict Mr. Williams. This is the definition of a biased judge and unethical prosecutors. The trial is constitutionally broken forever because of the outrageous actions of these three public officials, in quotations. Hilton told Mr. Copeland that he would be held in custody until every last defendant has been tried, not just the 6 on trial. Glanville sits mute and delegates his judicial discretion of punishment to lawyer Hilton because Mr. Copeland does not have to be housed in custody until every last defendant has been tried. Glanville, like lawyer Hilton, attempts to intimidate Mr. Copeland by telling Mr. Copeland that if he does not choose to testify, Copeland will be held in custody until all 12 co-indictees. This is just not true. In fact, Glanville is not even the judge on the other co-indictees cases, as same as being presided over by the Honorable Judge Dempsey. Instead of turning over Brady evidence, lawyer Hilton, with the support of Judge Glanville, explained to Mr. Copeland that he can simply testify, "I don't recall." Glanville, lawyer Hilton, and lawyer Love are inseparable and biased against Mr. Williams. Glanville advocates for the district attorney's office when he tells Mr. Copeland just tell the truth, while lawyer Hilton is telling Mr. Copeland just tell the truth, and let lawyer Hilton worry about the impeachment and Mr. Copeland will not get in trouble. This excuses Mr. Copeland from giving false statements to law enforcement officers with the statute of limitations tolling provision. However, Judge Glanville tells Mr. Copeland to not worry about criminal violations as the commissions of same would not get Mr. Copeland in trouble. Seemingly, Glanville, lawyer Love, and Copeland spoke off the record as Glanville recounts. He talks about how they spoke off the record because they reference that they spoke off the record. Thus, Judge Glanville and lawyer Love will be called as witnesses and cross-examined as to what was discussed off the record. Mr. Copeland states indirectly that if he confesses while testifying to murder, there is no statute of limitations for murder and he will be prosecuted. And lawyer Love stated that he will not be charged. Glanville sits mute. This Brady evidence never made its way to the affiant by Judge Glanville or Laura Hilton or anyone else in the Fulton County. This again is unforgivable. Moreover, when Mr. Copeland is speaking about murder, Laura Hilton states that if she knows Mr. Copeland is lying on a material matter under oath is judicial proceeding, perjury, Mr. Copeland would not be prosecuted for false statements. Again, this is just Brady evidence that Glanville and Laura Hilton failed to reveal. Glanville is no longer acting as a person on the judiciary, but is acting along with the lawyer Hilton and Love. Copeland told lawyer Hilton that she knew Mr. Copeland would plead the fifth. Lawyer Hilton denied same. Judge Glanville was silent. This is also Brady evidence and impeachment evidence. This makes lawyer Hilton and Glanville witnesses. Glanville assured Mr. Copeland that he will not get in trouble for testifying and his testimony will be impeached. Why would Glanville say this? This could be a false statement. This could be perjured testimony, yet Glanville is promising witness Copeland that he would not get in trouble. This is not conduct becoming of a judge in the great state of Georgia. Yikes, yikes, yikes. Miss Hilton told Mr. Copeland that he has spent enough time in prison for YSL. This is extrajudicial information to Judge Glanville that marks YSL as a criminal street gang, a material element of counts in the indictment, including one count of RICO. This statement marks that the person supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for Mr. Williams. Lawyer Hilton able to speak for Judge Glanville, who is present but silent. It is because they are one team. Glanville fights for the prosecution team by stressing to Mr. Copeland, they want your testimony, that's all they want, whatever that may be. Judge Glanville is an advocate for the state. Why does Glanville tell a witness that the state wants testimony and that's all they want? Why does Judge care about what the state wants testimony? Why does Judge Glanville care that the state wants a witness testimony? This is not concern of an unbiased judge. Glanville is a necessary witness also because they handed an unknown document to Mr. Copeland's attorney and Mr. Copeland's present. A client will cross-examine Glanville regarding why he would give this unknown document for Mr. Copeland. The jury needs to hear from Glanville so that he can determine whether Mr. Williams has been given a fair trial. Again, Judge Glanville and lawyer Hilton handed attorney Bumpus documents, who then gave to Mr. Copeland unknown documents. The jury has a right to know whether Judge Glanville has committed numerous ethical and unlawful violations. Judge Glanville must be recused. This honorable court, Judge KRAUSE, must also be recused as she sits on the Fulton County Superior Bench alongside Glanville and accepted re-election campaign money from Glanville. I swear that the above is true and accurate. Signed by Brian Steele. Signed by Keith Adams. And Judge KRAUSE has responded. Order denying motion to recuse Judge KRAUSE from hearing recusal motion. This case was randomly assigned to this court to consider certain motions to recuse Glanville from further proceedings. This court therefore must consider the portion of the supplement seeking this court's recusal before proceeding further. USCR 25.3. Assessing whether these three criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, but is a question of law to be determined by the assigned judge. Asserts two bases for recusal of this court. Defendant asserts that recusal merited because of a $2,000 donation made by Glanville to this court's recent re-election campaign. Williams also asserts that recusal was required because it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in the court which it sits in the same circuit. That's your homie, bro. You work together. It's you're exchanging money for campaign campaigns and you're in the same circuit. You can't really be fair. Williams supplements seek and recuse this score is supported by affidavit. Therefore, the first two criteria are satisfied, and the only consideration for the score is whether Judge Glanville's campaign donation to this court's re-election campaign warrants recusal. The Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to this case, does not warrant recusal where the contribution was not exceptionally large. And they cite Good versus State. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. So she's denying it. So this is quite obvious she's not going to recuse Judge Glanville. There's no mandatory requirement that the judge recuse, because under Georgia law, the asserted campaign contribution would not warrant recusal, and defendant Kendrick has not alleged any additional facts demonstrating he's not met the third criteria for a recusal. Defendant Williams' additional assertion of Judicial Qualification Commission Opinion 220 in support of this motion unavailing for first two important reasons. First, Glanville is neither party nor counsel in this criminal prosecution, nor is this a mandamus action, and defendant Williams cannot make it so by filing a recusal motion. So Opinion 220's conclusion that a judge should not preside in any action where one of the parties holds a judicial office in the same circuit does not apply to this circumstance. Second, and perhaps most importantly, defendant Williams' motion ignores the clear directive of Uniform Superior Court 25.4. That rule directs that in a multi-judge circuit, like Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random and partial case assigned method. The court does not relish the task to which it has been assigned, but it is as much of the duty as a judge to grant the motion to recuse when the motion is legally insufficient as to recuse when the motion is. For the foregoing reason, the portion of defendant's supplement and amended supplement seeking recuse court is hereby denied. So this is fucked. Tucker Daily also tweeted she issued a separate order denying Yakati's motion to recuse all Fulton County Superior Court judges from ruling on the recusal of Judge Glanville. So what do you know? This shit's corrupt. They're in the same circuit. They're donating to each other. One of them is accepting a $2,000 donation for their campaign. She's not going to recuse him. I'll tell you that right now. So at least that's my prediction. That's what's going to happen. So yeah, hit subscribe, like the video right now. Join the channel membership. It's only 10 cents per day. Love you guys. Peace out.